Good morning, Your Honour. Stella Robinson, counsel, appearing for the applicant, Mr. Tucker. Your Honour, the defence is seeking a pre-trial ruling pursuant to Section 590AA of the Code to have certain Crown evidence excluded from trial. Your Honour, the applicant is charged with trafficking in heroin pursuant to Section 5 of the Drugs Misuse Act and possession of more than 2 grams of heroin pursuant to Section 9 of the same Act. Your Honour, in this trial, as you will be well acquainted with, the Crown bears the evidential burden of proof to establish that the plaintiff is guilty of the charges against him beyond reasonable doubt. Your Honour, pursuant to Section 9 of the Act, the Crown must establish evidence to prove beyond reasonable doubt that the applicant had possession of a dangerous drug. Pursuant to Section 5 of the Act, the Crown must establish that the applicant carries on the business of trafficking in a dangerous drug. Your Honour, I seek to tender that all evidence found throughout the execution of the search warrant at the premises at Calder Road, Aspley, be excluded from trial. Your Honour, pursuant to the Police Powers and Responsibilities Act, Section 150, subsection 4, the application for a warrant must be made to a Supreme Court judge if the intention is to do anything that may cause structural damage to the building. Your Honour, on 3rd July 2023, Detective Sergeant Anderson applied to a magistrate for a warrant that would include the removal of an internal wall. Your Honour, on 5th July 2023, Detective Sergeant Anderson and other police attended the storage facility on Calder Road in Aspley to execute the search warrant. Upon entering the premises, in which Mr. Tucker was not present at the time, the police demolished the supporting internal wall. Your Honour, I therefore make the submission that the removal of the supporting internal wall was not lawful on the basis that the warrant was not issued by a Supreme Court judge. Your Honour, I further note that Section 158 of the Police Powers and Responsibilities Act provides that if an occupier was not present at the premises at the time the search warrant was executed, the copy of the warrant must be left in a conspicuous place. Your Honour, on 5th July 2023, Mr. Tucker was not present at the premises. The police executed the search warrant, conducted a search of the premises at Calder Road in Aspley, and left without leaving a copy of the warrant for Mr. Tucker. Your Honour, it is pursuant to Sections 150, subsection 4 and 158 of the Police Powers and Responsibilities Act that I seek to have all evidence obtained through the execution of the search warrant deemed inadmissible on the basis that the search warrant was invalid and therefore the evidence was unlawfully obtained. Your Honour, I draw the Court's attention to the cases of Crown and Ireland and Bunning and Cross. In consideration of the 5 factors drawn from these cases, I ask that you turn your mind to the circumstances in which the search warrant was obtained by police. Your Honour, the police knew they were going to remove the supporting internal wall, and yet they have failed to apply to a Supreme Court judge for the search warrant. This was in direct violation of the Act that governs them, in which I presume the police should have good working knowledge and understanding of their powers and responsibilities under this Act. I am of the mind that this was a deliberate breach of law and not a genuine mistake, Your Honour. Moreover, I cannot see how it can be established that the conduct was a genuine response to pressing circumstances. The police had conducted a lengthy surveillance operation of the applicant, Your Honour, and had considerable time to apply to a Supreme Court judge for a valid search warrant. Your Honour, whilst the charges against the applicant are serious in nature, the legislation serves the purpose of protecting individuals from unfair treatment. Your Honour, we draw on the case of the Crown and Day and Honor to ask that you consider public interest when exercising your judgment on the admissibility of the evidence. If Your Honour is of a mind that the evidence obtained in the execution of the search warrant is admissible, we seek you exercise your discretion to not admit it. Your Honour, in my submission we seek to tender that the evidence seen from the premises, specifically the cardboard box containing a DVD copy of the movie Trainspotting and related memorabilia, including a poster and magazine, should be excluded from trial. Your Honour, if we apply the test set down from the High Court of Australia in Goldsmith and Sandilands, I submit that it is circumstantial evidence only and is irrelevant to a fact and issue in these proceedings. Your Honour, I submit that the movie memorabilia cannot, on its own, prove or make probable that the applicant was in possession or carrying on the business of trafficking in a dangerous drug. If Your Honour does not agree and finds the evidence relevant to the facts in issue, then I submit that pursuant to Sections 135 and 137 of the Uniform Evidence Act and the Christie discretion deprived from Supreme Court case Crown and Christie, the evidence seized relating to the movie Trainspotted should be excluded from trial due to its probative value. Your Honour, given the nature and subject of the movie Trainspotting and its prevalence in popular culture, I seek to tender that admitting this evidence would be unjust due to its prejudicial effect against Mr. Tucker. If Your Honour is in agreement with me regarding the inadmissibility of the evidence obtained from the premise at Calder Road, Aspley, then I seek to submit as a matter of law that the proceedings against the applicant be dismissed for want of evidence. I do not see that the evidence is sufficient to prove all facts in issue to the appropriate standard. Without admissible evidence, Your Honour, the Crown cannot establish the elements or facts in issue pursuant to Sections 5 and 9 of the Drugs Misuse Act. Therefore, unless there is anything further, Your Honour, that is the applicant's submissions, and I defer to the authority of the court and trust that your decision will be the correct course of action. Thank you.